Hello, everybody. I'm going to give just another minute here. We're at the top of the hour, just another minute or two for people to log in before we get started. For those of you that just joined, I'm going to give another minute or so for people to log in, and welcome. We're glad that you were able to join us today. All right, David, are you ready to get started?
Yes. Good
morning. Well, first, before we get kicked off, I want to introduce myself. I'm Jana Langhorn. I'll be the moderator today. I'm the Senior Director of Marketing here at Synergistic. In just a minute, I'll turn over here to David. But before we do, I just want to give you a quick housekeeping items to go over. Everybody is on mute, but you can ask questions throughout the presentation by using the chat feature over in the control panel of GoToWebinar. And about 10 to 15 minutes before the hour, we'll stop to address the questions that we receive in the chat box. And just to let everybody know, we'll send a copy of the slides later, and along with the survey, that we would appreciate if you could fill that out to give us feedback on today's events. So with that said, I will pass it over to David. David Holtzman. He's our Vice President of Compliance Strategies here at Synergistic. He's considered a subject matter expert in health information, privacy policy, and compliance issues involving the HIPAA privacy, security, and breach notification rules. Prior to that, David served on the Health Information Privacy team at the Office for Civil Rights, where he led many initiatives, including the effort to integrate the administration and enforcement of the HIPAA security rule and health information technology policies. He has 2 decades of experience in developing, implementing, and evaluating health information privacy and security compliance programs from both the government and the private sector. With that, David, I'll turn it over to you.
Thank you, Jana, and good afternoon or good morning, depending on where you are, and I hope that you're having a beautiful, lovely day. Here in the Washington, D.C. area, we are having a beautiful sunny day in the 80s and no humidity. So I have to say, if I wasn't joining you on this webinar, I'd probably be at the pool. Today I want to talk with you about third-party vendor security incidents. And on our agenda, we're going to discuss, so sorry, I'm having a little technical difficulty here. Here we go. We're going to discuss just a short intro to kind of set the table, how we can prepare and how we can prevent a lot of security, vendor security issues, and prepare through having appropriate vendor management programs. And then I want to talk about what's reportable and what's not, with some specific focus on the increasingly fluid and area of state data protection and breach notification laws. And then we'll wrap up to share some thoughts about some experience that we have seen with some select large vendors who are in the healthcare marketplace. Please feel free to add your questions into the chat box that is on the webinar. And I think for purposes of our discussion, we'll go back to those questions at the end of the program. I apologize. I'm working off of a small laptop screen today, and I can't see the questions and the slides at the same time. So with that, there we go. Let's set the table a little bit. We're seeing a real spike in cybersecurity incidents. And these cybersecurity incidents are happening not just with our own organizations, but as we've outsourced more and more of information technology resources, functions, and processing, the same challenges that we are facing in our own organizations, we are seeing in third-party vendors. Here's some facts and figures. Healthcare is a target, and it's not limited to healthcare organizations. We're also starting to see an uptick in incidents that are with organizations that are either collectively providing ancillary health services like diagnostic imaging organizations, clinical laboratory service providers who have national networks of locations, and also with remote EHR organizations. And the fact is that these incidents are going to happen. We are constantly striving to implement better defenses and resources and become more familiar with how to prevent cybersecurity incidents. But the reality is that we need to prepare for the incidents that will happen, and that there are a number of causes to it, and there are probably the best offense is going to be defense at this point. In addition to the attacks that organizations are suffering, we're seeing a heightened regulatory environment. Now, some people will say it is blaming the victim for regulatory agencies to pursue compliance reviews and to implement fines and enforcement penalties against organizations that suffer these incidents. There's two sides to every coin, and I think from the regulator's point of view, that sometimes organizations may not be doing as much as they could be in basic information security practice to avoid the cybersecurity event or attack that they're suffering. And so we are seeing an expansion of investigations when there is an event, and the types of reporting requirements, even though here in the U.S. we have a sector-specific approach to setting the requirements for organizations, what their obligations to safeguard information and to report incidents as they occur. I think we're beginning to see a filling out of a regulatory enforcement structure that is going to be to some extent on the federal level on a sector-specific approach, and on the state level to a more inclusive pattern of data protection and breach reporting. So where do we sit as compliance professionals? And I'm going to tell you my bias right up front. I'm not a technologist. I'm not a cybersecurity guy. I got my start in privacy and pretty much view the world from a compliance and privacy construct, and how can I work with my partners in the information technology area, who are the information security officers. How can I work with them best to help my organization? And so I think it really is a good level setting to have some basic principles, and that I think those of us who are not information security technologists, and even those who are, we need to have some better coordination and communication. There shouldn't be silos in organizations in responding to these incidents, and everybody has a role to play in identifying and mitigating when a cybersecurity incident has occurred, as well as to help the organization both understand and make sure that the organization is fulfilling its obligations to report, as well as to facilitate communications with third-party vendors, and to volunteer or use our expertise to help the organization evaluate and better understand an incident that occurs at the hands of a third-party vendor. So one could look at how to at the issue of breaches and cybersecurity incidents, sort of in sort of a three-word paradigm. So prevent, prepare, and respond. So in my experience, really you can get a leg up on preventing third-party incidents by having a managed approach to understanding what services you're going to be outsourcing, to understand the information that will be contained in data that you're sharing with a vendor, and assuring that it's the appropriate information in order to get the job done, or another way to put it is use the principle of minimum necessary, and to make sure that you're selecting the correct vendor and putting into place strict controls as to how your relationship with that vendor will be. And then lastly, to ensure that at the termination of your relationship with the vendor, that you are appropriately seeing the disposal or the return of your information. So let's start with the thinking of, the best place to start in our thinking about how to prevent a third-party incident is to make sure that we are well acquainted with both the process for identifying and selecting vendors, but just as important, to define and to test the need for what type of vendor do we want and what type of information are we going to provide that vendor. And so at the outset of the pre-decisional selection of a vendor, to understand internally in our own organization what it is that we want the vendor to do, identify what security requirements we would have in place for the perfect vendor in developing service level agreement that includes appropriate privacy and security provisions, and to develop some standards that we would like to see that would pre-qualify and distinguish an adequate or good vendor from a vendor that just won't meet our needs. So So once we've developed an idea of what type of service that we want to obtain and the type of information that we're going to be sharing in that service, and what the vendor's role in creating or maintaining that sensitive information will be, we should put that or translate that into a RFI or a request for proposals, and to ensure that we are getting or putting ourselves in the best position to get proposals that will meet our basic needs, to have some basic tenets in that request for proposals that will allow for the submission of documentation that we need in order to be able to evaluate and assess appropriate vendors, and also to provide for the opportunity to explore with the vendor who's seeking to get our business how they are meeting certain requirements. So once we have selected a vendor or a set of prospective vendors, we should make sure that the service level agreement or the vendor contract contains specific requirements that we are going to require, both in the performance of safeguarding the sensitive information that we are going to be providing them and sharing with them, or that they will be creating on our behalf, but also specific requirements for how they're going to be meeting the basic data protection requirements. Notice how I'm not focusing only on HIPAA. While HIPAA is an important component, and if you've heard me present before, you generally have been focusing only on the HIPAA requirements. But one of the key issues that we are seeing, and I'm going to be returning to this theme through this presentation, excuse me, is that we need to expand our horizons and understand that state and federal requirements are being strengthened to have reporting and protection requirements for a broader scope of sensitive consumer personal information. So when we look at our statements, our contracts or our vendor agreements, let's be more expansive in understanding the scope and the type of information that needs to be protected, and what it is that we have expectations for how that information is going to be safeguarded. If it's not in the contract, then it's unlikely that the vendor will take on that responsibility. Another key feature is to hold the vendor's feet to the fire. Once they have got your business, to make sure that both the contract provides and that you follow up on assuring that the vendor has the processes in place to ensure that they are safeguarding information. An interesting point, recent discussion regarding the HIPAA Business Associate Agreement. Many organizations have been including in their Business Associate Agreement provisions that are in excess of the required requirements under HIPAA to safeguard and to protect PHI from unauthorized use of disclosure. Most recently, we had a discussion with some folks about they had included a requirement for SOC 2 audits to be performed in addition to the security management processes of a risk assessment that's required under the security rule. Well, under high tech expanded the obligation for covered entities to hold their business associates accountable. So, the general rule is that if you're a covered entity, you're not responsible for your business associates' actions under the business associate agreement, with one exception, and that is if you have direct knowledge that your vendor is not performing to some provision that's required in the business associate agreement. So if you have a SOC 2 requirement in your business associate agreement and you learn that in fact your business associate is not performing those SOC 2 audits, if there is an incident and it is attributable to the lack of having appropriate security safeguards, you, the covered entity, could be responsible for the lack of attention to forcing your business associate to comply with your business associate agreement. Whereas if you had that same requirement in your service level agreement or your vendor agreement, then OCR would not hold you accountable. It would just be merely be an issue of contract to be enforced. Another important feature is how incidents are reported and breach notification. So here again, while HIPAA has been the predominant driver of this activity, we now have to be thinking more broadly as to what the state data protection and breach notification requirements are, and how long the vendor has to respond to us, what type of information they have to provide us, and can the responsibility of notification be delegated to the vendor under the state law requirement, or under the state law requirement, just like with the HIPAA requirement, is the covered entity or the data owner ultimately responsible for notifications to the public and to any regulatory agency. Just as importantly, a last component is to understand and to have in place clear and precise requirements for what happens at the termination of the contract. Every good business relationship comes to an end, and it's vital to have some provision in place for either the secure disposal of sensitive personal consumer information or for its return to the data owner. We have seen a series of incidents that have occurred at the hands of business associates whose services to the covered entity had ended a long time ago, and the covered entity had not followed up with their old business associate to confirm the destruction of the data, or to ensure that the data was returned to them. And as a result, even though they had no relationship with an organization for 5, 7, 10 years, when a breach had occurred, the covered entity was still responsible for that notification process. And so, word to the wise is to include in your vendor agreement information about contract termination, as well as to follow up on that and to make sure it happens. Excuse me. So in your agreements with vendors, make sure that you are addressing key needs that will be top of mind in the case that there is a vendor an incident with that vendor. So make sure that your agreement has provisions that cover you for the main causes of security incidents that are occurring not just at your organization, but these same types of incidents are just as common when they happen at vendors. And we have to make sure that we have provisions in our agreements with the vendors that will provide for flow of information, explanation, and the ability to investigate when an incident has occurred at a vendor. So let's switch gears now and talk about how do we prepare for assessment of an incident that happens at the hands of a vendor. It's many of the same concepts that we would use for our own preparation and incident response are transferable to how we would approach an incident with a vendor. And so largely, the first question you'd want to ask, see if you can quantify or qualify what data we're talking about that's been involved in an incident. And also, as we are looking at what type of data we are sharing with our vendor or they're creating on our behalf, to be able to appropriately classify and identify what type of information it is, and that will help us with understanding, is it protected under federal law or state law. And it's also important to have a clear understanding of what is a reportable data breach under the appropriate federal or state law, and oftentimes they are both. The fact is that generally the federal law does not preempt or do away with any requirement that's under state law. And in addition, what we are seeing with new state laws is that they are instilling provisions that are different and in some cases more rigorous than the HIPAA requirements. So in dealing with an incident from a vendor, we have a series of questions that we need to answer in order to be able to assess whether a vendor's incident is reportable for us, because our organization, the data owner, or in HIPAA terms, the covered entity, we are ultimately responsible for taking the report that's provided to us from our vendor and in doing a de novo review. In fact, one of the recommendations, and as we'll see in our discussion of a large vendor relationship, it's important not to just take their word for it. So, in my opinion, it's not reasonable or it's not good practice simply to take the report of the vendor and rubber stamp it and to just file it away. It's important and it's expected that the organization will do its own analysis of the report from the vendor. And in order to do that, they have to make sure that they have the appropriate information from the vendor. So in performing this review, there are several key questions that an organization has to be able to answer. And again, if your organization as the data owner or the HIPAA covered entity doesn't feel it has the information that it needs to return to the vendor and ensure that they can get this information in order to be able to answer these questions. I put on here the point that some organizations may choose to assert attorney-client privilege over the activities and the analysis and the assessment that they are doing. So if organizations should be consulting with their in-house or outside legal counsel to determine if that's a benefit for them. Likewise, we are seeing that some vendors are asserting attorney-client privilege over the information that that organizations are seeking in order to be able to evaluate if there has been a reportable breach. If you have a vendor who is asserting attorney-client privilege on information that you need in order to do your assessment, I'm afraid that the only recourse is to reach out to legal counsel and get their advice on to answer the questions. Is the vendor supplying you the information that they are legally obligated to provide, or they're obligated to provide by the terms of your vendor agreement, or in some cases the business associate agreement? So the triggers for notification are going to be found in either statute or contract. So remember, looking beyond the veil of HIPAA, there are a number of issues to determine. What are the requirements that your vendor has to you, and what requirements do you have to a state, federal regulatory agency, or to other business partners that you may be processing or handling data for. And then the second step is to learn what the statutory or regulatory requirements for notification are, and to understand those triggers. And these can be sometimes complex, and they may turn on specific types of data, again, this is an instance where you may want to bring in legal counsel to make sure that there's a clear understanding of what the requirements are, and to help in performing in that assessment. Don't take on the risk of doing this by yourself. Bring in others with appropriate expertise. So in HIPAA terms, I think we're all pretty comfortable with sort of the broad outlines of what the HIPAA breach notification requirements are. We have that it hasn't changed since the implementation of the requirements in the Omnibus Rule and in the HITECH Act. Still have this 60-day window as an outside marker. Although there's this language that there shouldn't be unreasonable delay, and it's important to bear in mind that your vendor should be notifying you in whatever time window you have set in your business associate agreement. But beyond the definition of what is a reportable breach, you'll note that there's also in every business associate agreement, and oftentimes in vendor agreements that are for data that's not subject to HIPAA, that that there is a notification requirement from the vendor in the case of a security incident. And I know that I've been speaking with clients who have had difficulty enforcing these provisions. And so one of the recommendations that I would put out is to, if you haven't heard from a vendor in 3 to 6 months with a report of any security incident, I think it's good proactive practice to reach out to that vendor, touch base with them, talk with your point of contact, the compliance officer or information security officer at that organization, and learn if they have had security incidents, and learn if why they haven't been reported to your organization. I'd be remiss if I didn't include some baseline HIPAA security, HIPAA breach notification rule requirements, again, these have not changed since the implementation of the omnibus rule. There is this presumption that if there is unauthorized use and disclosure of PHI, that it's a reportable breach. There is a safe harbor for unreadable or unidentifiable PHI, and this same safe harbor has also been adopted by most of the state breach requirements. And that there is a requirement that you assess to determine the probability of compromise if you're not going to, or if there's a question about whether a breach is reportable. And we've still seen some variance in the assessment tools. Our recommendation is to stick with the tried and true four-question test that is taken directly from what is the definition of a breach in the breach notification rule, and that's in the 2013 omnibus rule, and then not to add too many additional questions, because our experience is that organizations kind of shoot themselves in the foot when they add additional questions, because there's this natural tendency to have some type of risk, to add some type of risk of harm assessment or analysis to an assessment that really is only about what is the probability of compromise to the data. And then, of course, in OCR's ransomware guidance, they added 2 additional questions that should be examined in the case of a ransomware incident as to the risk of unavailability of PHI and integrity of PHI. We've not seen any OCR enforcement actions involving a ransomware incident or where an organization system has been taken over by a third party. So absent any guidance from OCR on how to apply this standard, we're simply going to take it at face value and just recommend that these 2 issues be addressed in doing an assessment. So how do we take this and apply it to the ever-expanding state law requirements? So one of the challenges is that we first have to have a clear understanding of whose data are we handling and what is the criteria involved. One of the trends that we are seeing in the development of state state law breach notification and data protection requirements is that it applies not to where the business is located or where you are doing business, but it applies to the data of the residents from residents of that state. Or to put it another way, they're applying a long-arm approach to enforcing their data protection requirements. Give you an example. You can take California, Massachusetts, or Colorado, and they apply their breach notification and data protection requirements to sensitive consumer information that's being held by any organization throughout the country. And if there is a breach, if there is an incident, you have to measure the requirements of that foreign state's data protection and breach notification requirements against the incident that has occurred, oftentimes in another part of the country. So, but there are some key elements that we're seeing in the state data breach notification requirements. They all have a definition of personal information, and some of these definitions are uniform, and some states are outliers. And unfortunately, you or your legal team needs to do an analysis of each state law that may be applied to understand that definition of what is personal information. 49 of the states have a safe harbor for encrypted PHI. And in addition, many states, I shouldn't say it, a number of states also apply their breach notification and data protection requirements to PHI that is in non-electronic form. Each state law has some type of explanation or definition of what is an unauthorized or improper disclosure, and they also identify who is an unauthorized party and what action that unauthorized party must take in order to be able to define exactly what is a breach. Confusingly, many states do have some modicum of a risk of harm standard, and there is some uniformity in that there must be evidence that the consumer data has been misused, or that there's a reasonable likelihood that it has been misused. But again, there is no real uniformity, and one has to examine each and every state statute that may come into play. Another key issue is that we're seeing these state laws being revised and modified almost on a monthly basis. So, for example, some states are expanding or making more stringent their data protection requirements, or expanding the types of information that's being protected. For example, biometric information is being added to many of the state law requirements that would be in addition to just name and account number and other type of key features. So the requirements do vary by state, but one key important thing to remember is that now each state and territory in the U.S. has some data protection requirement. and breach notification law. Up until this year, there were a couple of exceptions, and some of the state laws that were on the books, in addition, were essentially requirements that were in name only. But we are seeing more and more attention being paid to data protection requirements. So in addition to the variability in defining what is a breach, we're also seeing the same variability in the notification to individuals. And this is important because many of our vendor agreements will include provisions that delegate the notification requirement to the vendor. And a number of state laws that have recently been enacted don't recognize don't recognize the transference or delegation of that. So the organization that is the data owner, or in HIPAA terms, the covered entity, is ultimately responsible for the performance of the notification, even if they have delegated it by contract. Another key thing to remember is that several, not a majority, but several states are setting out requirements for the form and the format of the notification and what must be included in that notification requirement, and also to provide notification to the Attorney General or some other organization, regulatory agency within the state. It's important when you're dealing with an incident that originates at a vendor that, number one, you have clear information so that you can fulfill whatever content is required in the notification of that state, but also to ensure that if there's a delegation to your vendor for notification to individuals, to ensure that whatever notice that they are using complies with the requirements of the many states that they may be doing business in, because they have any number of clients who may be affected by a breach, as well as all of the states that you're doing business in. So there is a general trend of what has to be included in a breach notification letter, and also it's good to remember that the HIPAA breach notification rule also has some basic content requirements. In looking at the various state breach notification laws that have a notice content requirement, they are all the same as or more stringent than the HIPAA requirement. I do want to call out that we are seeing some states that are setting a requirement for having some type of identity monitoring and protection service, or making the consumer aware of the availability of those services. And then we have the outlier in California, which is if you offer these services, they must be prepaid for a year. So as we have seen more and more incidents that are occurring across all of industries, healthcare included, in which we've just seen a waterfall of personal consumer information being disclosed, we've seen heightened enforcement activity. And these activities, we're seeing, pardon me, we're seeing more, especially more involvement by state attorney general's offices. And for those of us who have had experience with compliance reviews under the HIPAA breach notification rule, in compliance reviews with the Office of Civil Rights, I think we can all agree that cooperating with investigators and having transparency is a better practice than taking an adversarial approach. And especially with state attorney generals, we are seeing a greater use of on-site visits and coming to a facility for an investigation. And, frankly, I think it's an issue of expense and logistics. The state attorney general usually has representatives located throughout the state, and so there are folks who are generally not too far away from your vendor's organization or from your facility who can perform an on-site visit to investigate a breach or a security incident. And a key feature that we see in these investigations is that the regulator wants to see some demonstrable action that was taken in response to the breach. Whether that incident was at the hands of your vendor or whether it happened directly in your organization. We most recently saw an investigation in New Jersey where the incident happened at the hands of a third party, and yet the healthcare organization was held responsible because, in the terms of the Attorney General, they did not react strongly or quickly enough to ensure that the vendor was protecting the data as required in their contract, and it became then an unfair trade practice. So in the few minutes that we have left, I want to talk about some trends that we've seen with some large healthcare vendors. And so I don't unfairly brand any of the large players that we've most recently seen some breaches from. I'm just going to make some more general comments. And I don't intend for these to be taken as a criticism for any organization. So what we have seen by and large is, first of all, the large organization is taking steps to put out a communication to affected organizations relatively quickly, and it's probably just good practice, and that the healthcare organizations, the customers of these large organizations, the last thing they want to do is get their news about an incident from the media or read about it online. So it's important that they get out in front of these incidents. On the downside is that many of these communications are being carefully crafted with the help of legal counsel, and it seems by and large that legal counsel is directing a lot of these communications, and so that has resulted in sometimes the information being cast in the best light and not providing enough information to healthcare organizations to help them understand the scope and the depth of the breach or the incident. And then we are seeing follow-on communications that are more definitive, that provide additional information about the scope and depth of the breach, and also provide the required information notifying an organization exactly which individuals have been impacted by their data. that has been disclosed. The challenge is that oftentimes this does not include information as to what state the individual may be residing in, and the organization needs to then track back within their own records to determine the appropriate state of residency from that information. We're also seeing a trend where organizations are being provided a breach assessment in line with the breach assessment, the four-factor breach assessment under the HIPAA HIPAA breach notification rule. The challenge here is that the vendor is using summary information, and they're not providing the information needed for your organization to be able to perform the assessment it needs to perform in order to understand the scope of the breach and to be able to perform its de novo assessment to determine if, in fact, it's a reportable breach. And you're placed in the uncomfortable position of having this piece of paper, if you will, in which the organization makes assumptions and analysis that you don't have a lot of evidence to back up with. And in fact, in a couple of incidents, we have seen breach assessments which carefully lay out an incident that on paper looks like a reportable breach, and yet the organization will apply a low probability of compromise to that breach, and that puts you in an extremely uncomfortable position. It's important to work to seek the appropriate information from these vendors. If they're not giving you the information that you need, then it's important that you stand up for your legal and contractual rights and recommend that you seek out advice from your in-house counsel or your outside counsel, and to be able to demonstrate that you are taking appropriate action. So with that, I will stop. I know I have some additional slides, and I'll look for any questions that maybe have been on the chat room.
Thank you so much, David. There is a couple of people that have asked about the slides. So again, as a reminder, we'll send out a link to download the presentation after this webinar. But then, David, there was a couple of questions I did receive via the chat, and reminder to anybody that's still on that you can send any questions through the GoToWebinar chat feature. One of the questions I had was, is there an industry standard privacy and/or security questionnaire for pre-contract phase when vetting a vendor?
We have not seen a pre-contract questionnaire. We have a questionnaire that we've developed that can be generalized for a number of different types of vendors. One of the challenges is that the questionnaire should be customized for the type of service that's going to be provided, as well as the type of information that you're having the vendor create or manage for you. So to some extent, there isn't a good one-size-fits-all approach, but there is a baseline that we can share with folks who are interested, and you can contact us for a copy of that.
Thanks. And then it looks like we've got just another minute. Another question I received was, we had to negotiate heavy on limitations of liability as vendors want to cap low. Due to the increase of breach cost, is there a spreadsheet that accounts the true cost of breaches, such as reputation damage, administrative and legal fees, regulatory fines, etc.?
So unfortunately, there isn't. The estimates are all over the block, and to some extent, they are unique to the type and size of the organization, as well as if you're doing business in a location that's more litigious than another location. In addition, some states have a private right of action. Other states do not. So, I'm afraid I don't have a good answer.
All right. Thank you, David. With that, I do want to be respectful of people's time. We are here at the hour, so I want to thank you for this informative presentation, as well as thank everybody that joined us today. And we will be sending out the slides and a short survey later this afternoon for everybody that joined us today. Thank you.
And thank you, everybody, for joining us.